Hello everyone, I'm the attorney Carlo Pontei from Mangata Avvocati. Today I'd like to walk you through an important ruling issued just yesterday on July 31st, 2025 by the Italian Constitutional Court. We will calmly analyze the legal reasoning behind it and most importantly understand how this decision can strengthen your case, especially if you are challenging the new law number 74 of 2025. This decision stems from three separate referrals made by the civil courts of Bologna, Milan, and Florence. These judges questioned the constitutional legitimacy of the law number 91 of 1992, basically the law that governs Italian citizenship. More specifically, they asked whether it was constitutional to grant citizenship by descent or Jure Sanguinis with no time limits, no general restrictions, and no requirement for current ties to Italy, relying solely on bloodline. In other words, they asked, is it constitutional to recognize Italian citizenship to someone simply because they descend from an Italian ancestor who emigrated more than a century ago? The Constitutional Court gave a strong and unambiguous answer. Yes, the recognition of Italian citizenship by descent is fully compatible with the Constitution. The court emphasized that this method of granting citizenship is the result of a political and legislative choice, grounded in Italy's historical experience as a country of immigration. Citizenship by descent is not a discretionary benefit, but the recognition of a pre-existing legal status. In fact, the court confirmed that Italian citizenship is automatically transmitted from birth and the right to have it recognized is not lost over time. From a legal standpoint, the court's decision rests on three key principles. First, legislative discretion. Only the Italian Parliament can define the rules governing citizenship. Courts, including constitutional judges, cannot impose limitations where the law has not done so. Second, the protection of citizenship as a fundamental right under Article 22 of the Italian Constitution. Citizenship cannot be restricted or denied arbitrarily, especially when it results from birth and legal descent. Third, the prohibition of judicial overreach. The court made it clear that it cannot rewrite the law or correct perceived flaws unless there is an obvious and undeniable violation of the Constitution. This ruling does not directly address the new law number 74 of 2025, but it sets a very important precedent for those of us who are challenging the constitutionality of that law. As you may know, law number 74 introduced severe restrictions and citizenship applications, including mandatory residence in Italy, the exclusion of descendants whose Italian ancestor lost citizenship, and most controversially, the retroactive application of these new rules to cases that were already filed or pending in court. So, now we must ask, if the Constitutional Court just ruled that not even a judge can introduce new limitations, how can it be constitutional for a new law to do so retroactively, stripping away rights that were previously granted? The answer is that this really significantly strengthens the legal basis for arguing that law number 74 is unconstitutional particularly in regard to retroactive restrictions, violation of the principle of legitimate expectation, and disruption of an individual's permanent and imprescriptible legal status. This decision should now be included in every judicial petition challenging the new law. It provides a solid constitutional foundation to argue that the legal framework for citizenship by descent has not changed until recently, and was repeatedly confirmed by both lawmakers and courts. The new law violates the principles of reasonableness and proportionality under the Article number 3 of the Constitution. It infringes on the right to maintain one's legal status under the Article number 22, and it determines the legal certainty by applying retroactive changes to people who acted in reliance on the previous rules. In short, this ruling confirms what we have long argued: Italian citizenship by descent is not a gift. It is a right, and one that cannot be taken away lightly. This decision represents a turning point, a very important turning point. Even though it does not invalidate the law number 74 directly, it lays the constitutional groundwork for future challenges. That is why at Mangata Avvocati we are already preparing strategic petitions based on these and other decisions to defend the rights of individuals who are now unfairly excluded. If you're wondering whether this decision could strengthen your case, get in touch. Please remember that every situation is unique, and even a small detail can make a big difference. Subscribe to the channel to stay updated. The next major ruling from the Constitutional Court will be expected soon, and will be ready. Of course, we'll be ready. So, thank you for watching, and see you in the next video.